Welcome back to the last chapter of Business Law 1. That's chapter 16 regarding remedies to contract breaches. We're talking about remedies, and up till now we've been focusing on the problems. So now we're going to focus on the solutions. In this chapter, we're going to learn about sometimes happy endings of contract disputes. As an entrepreneur, you can have hope in our legal system that it has the power to cure a contract gone wrong. So the purpose of a remedy, the purpose of what the court's trying to do, the purpose of a lawsuit is to make the non-breaching party whole. Okay, so they've suffered damages as a result of the breach, and we're trying to make the non-breaching party whole and the breaching party pay those damages. And the questions on the exam are mostly going to have to do with figuring out what the damages are that are to be paid, because that's going to be the remedy generally. Then there's equitable remedies, which is things that are different than just money damages. And those include specific performance, injunctions, and a different way of looking at money, which is restitution. That restitution is restoring the party back to how they were before the contract started, which is different than damages that are supposed to make the party whole based on benefits that they were supposed to get if the breaching party had not breached the contract. So generally, this is a free country, and you have the power to breach a contract, but you don't have the right to do it because it comes with the damages of the breaching party. So let's see. You can imagine situations where breaching is actually the preferred outcome. So maybe someone has a contract to give vaccines, COVID vaccines, and they find out that the vaccine is defective. Well, that contract, needs to be broken. It needs to be breached in some way. I guess a third party would have breached by not providing the right vaccine. But if the contract was for providing the vaccine and it was known that the vaccine has a flaw, then we want to dissolve that contract in a case like that. Now, where promisees' interests are protected by a contract, we look at three signs of that. There's expectation, which is when a benefit is bargained for. There can be reliance, which is when there's loss suffered by relying or the actions consistent, and or restitution, which I mentioned earlier, is reimbursement to restore the promisee to pre-contract position. So for example, here we're talking about a $100,000 garage that's being built, and $90,000 of that contract was supposed to go to labor and supplies. So $90,000 was supposed to go to labor and supplies, and $10,000 was going to be profit for the contractor. So that's a pretty simple contract. And if the person who wanted to build the garage suddenly ran into a situation where they couldn't pay $100,000 for that garage and they had to cancel the contract, then you just subtract $10,000, which was the profit, from the $100,000. Let's say no supplies or labor has been expended yet, and the person cancels the contract. So the damages in that case are $10,000 expected profit. So that's, when I talked about expectation, that's how you can figure out the damages in that contract. Now, if we make the situation a little bit more complex, we say, let's say the contractor already started the foundation of the garage, and he calculated that he spent $15,000 on that foundation. If the purchaser at that point cancels the contract, then the damages are going to be the $15,000 that were spent on the foundation plus the $10,000 profit. So you could see the answer, the damages, the remedy in that case would be to award the contractor $25,000. All right, getting more into damages. Like I said, damages are generally money. So the only thing the court has the power to do when it comes to damages, if they can be quantified by money, is to figure out that math problem and award a judgment to the non-breaching party for the damages that are assessed as part of the breach. So there are basically 6 types of that. We've got compensatory damages. And like I said, that's easy to figure out. $10,000 profit for a $100,000 garage. And that's different from a situation where maybe you had a personal performance contract with a portrait painter. So you wanted the portrait painter to do a job, and let's say the job was lost and the portrait painter is able to find another job for $30,000. Well, then the difference is the $5,000 in damages. We've talked about the duty to mitigate damages. So in those situations, the non-breaching party, while they're entitled to damages, they have this duty to mitigate damages. And as long as they make a good faith effort to do that, they can recover the whole amount. On the other hand, if they are able to offset some of the damages by mitigation efforts, getting another job, for example, in this example, the contract was for $35,000. The job's canceled, and a painter finds another job for $30,000. Well, then there's still $5,000 worth of damages. So that's compensatory damages. Then we've got incidental damages, and that's from sort of minimizing the loss. If, like I said, we got a canceled contract and the non-breaching party has to take an ad out in the paper or on Craigslist to mitigate the damages, the cost of that is incidental damages, and those will be awarded by the court generally. There's consequential damages, and that's in a situation where, for example, Ralph's poor plumbing causes floor and ceiling damage in a home. So you can imagine a plumber should be aware that faulty plumbing is going to cause the consequential damages of water leaking down through a floor to the ceiling. And a professional is going to be responsible for that. A plumber that's why we license plumbers, because there's consequential damages in that. Lawyers too, if we make mistakes, that's why I have malpractice insurance. There can be residuary damages in cases like that. There's nominal damages, which, even if there's not significant damages proven, small ones will be enforced, nominal or small damages. And that can trigger attorney's fees, for example, in a contract. If it says something like the winning side in any lawsuit will have to, the losing side will have to pay the winning side's attorney's fees, well, then even nominal damages can trigger that. Liquidated damages, we've talked about this a bit, and that's when damages can be difficult to assess and we build them into the contract ahead of time. Give you an example of a Santa suit we talked about in class. And let's say you're a professional Santa, your Santa suit got burned in a fire and you need a new one. So you contract with someone and you tell them, time is of the essence. I need the Santa suit by Black Friday, because if you're a mall Santa, that's when your duties start, and then they end when Christmas comes around, and then nobody sees the mall Santa after that. So if you get the Santa suit the day after Christmas, it's basically worthless for that year. So what you would do in a contract like that is you would build in liquidated damages. And the concept of liquidation we talked about is sort of turning assets into money, and liquidated damages are taking something that's hard to assess, but it has to have some basis in reality. So what you would do if you're the mall Santa is you look at how much did I make last year on Black Friday, or how much did I make between Black Friday and Christmas? And then you divide that by the days in there, and you make liquidated damages per day until between Thanksgiving or between Black Friday and Christmas. And if it arrives somewhere after Black Friday, and let's say it's $1,000 a day liquidated damages, then it's built into the contract. And those will generally be enforced if there's some basis in reality and they're not just considered a penalty. So if you put liquidated damages into a contract and it has no basis in reality, it's just a penalty if someone is late on something, then a court won't enforce that. But if it has a basis in reality, it can be enforced. Then we've got punitive damages, and we talked about that in the McDonald's coffee cup case. And that's where, a plaintiff can ask for punitive damages, which aren't, necessarily suffered by the plaintiff in a case or the non-breaching party. But if the act was willful and malicious, we think of the justice system and that the court has the power to award punitive damages. All right, next is equitable remedies. So these are things outside of money damages that a court can award. And one is specific performance. So the example in the book would be a Russian heirloom, piece of jewelry. And if you contracted with someone to purchase that, and then the seller, while they didn't give it to you yet, sells it to somebody else, maybe gets more money out of it. It's a free country and they have the power to breach that contract, but they don't have the right to do that. So a court can force specific performance because there's no other way to resolve that breach by ordering specific performance. Next is an injunction, and that's generally when a court stops someone from doing something that they've already maybe started or they have a hint to do that. I'll give you the case in the book, which is Madison Square Gardens versus Carnera. Carnera had a contract to box on a certain date and not to engage in any boxing matches in between, because you can imagine if you're contracting with the best fighter, you want that fighter to be full strength and not to have engaged in potentially injury producing fights in the meantime. So when Madison Square Gardens discovered that Carnera had another contract, they got an injunction and stopped him from doing that. Okay, restitution, and that is restoring one party to their pre-contract position. So a little different concept than damages, which is to make the party whole as if the contract was not breached. So that's the distinction between restitution under an equitable remedy or damages, which are part of the legal remedies. All right, some examples here. Calhoun builds a $3,000 fence. It's valued at $3,000 in the market maybe, and he builds it for $2,000. And if Arlene refuses to pay for that, then the damages are the sale price of the contract, not the $3,000 what their market value worth. So the court will look to what the contract is primarily for what damages are if it's spelled out in there. Just like if you're a doctor and you save someone's life, you don't get their earnings for the rest of their life. You get the price of the performance of the contract, how much surgery costs or whatever else is done. Past performance and then a breach. And that would be when a benefit is conferred, which is greater than the non-breaching party's loss. And the idea here is preventing what we call unjust enrichment. Okay, so an example is Arlene is to sell land to Calhoun for $120,000. A $30,000 partial payment is made, and then repudiation happens, and Arlene sells the land for $110,000. Okay, Calhoun would get $20,000 in that situation because you've got the $30,000 down payment and a larger or a reduced sale price. And then let's see, limitations on contract remedies. Basically, you must be able to articulate foreseeable certain damages. And a big case that we learn about in law school, it's also in the book, having to do with foreseeability, is Hadley versus Baxendale. And that's from England in 1854. The defendant promised to deliver a millstone in 2 days. Okay, what they didn't know is that the village was without an operable mill while they were waiting for that. So the court said that there wasn't notice that time was of the essence in this case. They delivered the stone, but they did it by canal, which is a much slower delivery method, but is cheaper. If they knew that those damages were going to happen, then they would have stuck to that contract to get it within 2 days, and they would have taken a faster method to get there. So, the court will also consider proportionality in a case like that. So, if you're contract to make a millstone, if you know that a village doesn't have one, then you can foresee that there's going to be damages. There's lots of people that need to use the mill to cut wood, to make flour, things like that. So the damages could be foreseeable, but in this case, because they weren't given notice that there was no millstone, the court ruled that those weren't foreseeable damages. Mitigation of damages, we talked about that, and it has to do with that good faith standard, the reasonable person standard, and we want to avoid loss wherever possible. So it need not be successful, just has to be in good faith. So if someone leaves an apartment and leaves it empty, but they agreed in a lease to lease it for a year, if they leave it in the middle, the landlord merely has to put out an ad and try to re-let the apartment. And if they're not able to, then the original tenant is on the hook for all that rent. Certainty of damages. So they have to, only damages with reasonable certainty are recoverable. So, a contract where ALF has a contract with the manufacturer for $300,000 and those belts are lost, it has to be, there has to be some connection to reality with what the market value is in a case like that. All right, loss of power of avoidance. So we've talked about earlier in contracts, duress, undue influence, misrepresentation, mistakes. And then there's the concept of affirmation. And that's when, someone maybe can't engage in a contract because of their age, they're under 18, but they take out a credit card or a loan and the other side, overlooks it or doesn't know it. But then they turn 18 and they keep making payments or they keep using the service. Well, that is what's called affirmation of an otherwise voidable contract. We've got the, sometimes there can be an agreement of the parties limiting remedies. So that's okay as long as it's very conspicuous and it's bargained for and it's conscionable. So the example in the book is concrete. So if you put a warning on a concrete label and you say that attention, our sole liability in the case this product is defective will be to provide you with like quantity of non-defective material. We will not be liable for other damages, direct or indirect, express or implied. And if that's out there, it sort of is evidence to the court that other damages, if concrete is faulty, are not foreseeable by the company. Election of remedies. Sometimes, there can be different theories about the kinds of damages or equitable relief is available. And at common law, you have the option there, but the UCC generally rejects that. I won't be testing too much on that. So for this, so don't worry about it too much. All right, on to our cases. We've got EBWS versus Britley Corporation. This is a case from Vermont in 2007. And what we had there was there was a creamery and they had contracted with a construction company to build the facilities to make the creamery. They had a dairy farm and they had been selling the milk to other creameries. And then they decided to have this creamery on the spot and it needed repairs. It stopped, they weren't able to function. And so the construction company came back and fixed it. And in the meantime, the creamery didn't have work for their employees. So the employees lost wages and they threw out the milk because they didn't have a creamery to use. And a jury awarded those damages, but the appellate court reversed, saying that those damages weren't necessary and foreseeable. They could have sold the milk to someone else to mitigate the damages. And also they didn't have the duty to the employees. Those are at-will employees. So if they don't have the creamery to operate, then those employees should try to find other work or use unemployment is sort of the decision of the court in that case. All right, a case involving liquidated damages from the state of Washington in 1994, Watson versus Ingraham. And in that case, you had a house that was contracted, and the full sale price was $355,000. And while in between the contract and the closing, they weren't able to buy the house. So a $15,000 deposit was made at the time the contract was made, which is pretty standard that a deposit gets put down. It's not always that high, $15,000. But the idea is that during that time in between the contract and the closing, the house is taken off the market because both parties are committed to that closing. And if someone doesn't fulfill their end, the buyer here doesn't come up with the rest of that money and says they can't, and they maybe counter offer something that wasn't contemplated in the contract, which is what happened here. And the seller didn't want to accommodate that. They said the contract was for full performance, give the full amount of money when the closing was, and they backed out of it. And the seller in that case kept the $15,000 deposit. And the buyer said, well, that's kind of steep for how much actual damages are. And that's the beauty of liquidated damages. If it's built in the contract and there's a basis in reality for the loss of that money, then the liquidated damages that are built in the contract will be enforced, because a court doesn't want to go and substitute their own judgment for what actual damages are when liquidated damages are built into a contract. Now, it can't just be a penalty. There has to be some basis in reality for it. And here, they missed out on the house being on the market and getting other bids. They could have maybe gotten even a higher bid, but they were committed to this individual who had good credit at the time. But something unforeseen happened, and that's the risk that person took on. So they lost their $15,000 deposit. The next case we covered already, that's Madison Square Gardens versus Carnera, and that had to do with injunctive relief. And the last case of the semester is Shirley MacLaine Parker versus 20th Century Fox. This is a case from 1970, California. If you can imagine, Shirley MacLaine Parker was a successful actress, also a singer, and she contracted for $750,000 for a film that was going to be a musical called Bloomer Girl. So she was going to be the star, and it was going to be a musical role, right? What she wanted in California, being filmed there. And what they did, the 20th Century Fox said, well, we're not going forward with that film anymore, and we're going to offer you a substitute film. And we want you to take this role. It's called Big Country, Big Man, and it's a Western role in Australia. It'll be a lot of fun for you. How about this one instead? And what she said, and her agent, is that this is not a substitute that fulfills the contract, because it's fundamentally different. First of all, you got to go to Australia to film it. You can't work on other projects in California where there's a lot of entertainment going on. The other thing is she's not the lead role. It's not named after her. So it was a fundamentally different big concession from what was contracted for. This one's called Big Country, Big Man, and wasn't really a musical. So the court ruled that that was not adequate mitigation of damages. So, in spirit, they were good, trying to offer her another role. However, it has to be something that's really going to mitigate the damages, not set the person back. All right, that is the end of Chapter 16. That's the end of Business Law 1. Good luck on the exam.